Welcome to the Friday Five for November 11th, 2022. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to look at 5 questions that came up this week. First of all, it's November 11th, which is Veterans Day, so happy Veterans Day and thank you for your service to all veterans. If you're watching this, then we truly appreciate what you've done for us. Diving right into our 5 questions. Number 1, how do I name my trust? So when a client wants to create an estate plan that has a trust built into it, whether it's revocable, meaning it can be changed, or irrevocable, meaning it cannot be changed, one of the biggest questions we have is how do we name that trust? A common trust name that we will run into is you can use your name or you and your spouse's name or your family name as part of the trust. However, if we want to own things in the trust and we want to be a little more opaque about who those owners are, you can consider different names for your trust. We've talked about it before, things like the Golden Wallpaper Trust. It doesn't tell you who owns it. It gives you a little opacity when people are trying to figure out what assets are in the trust and who owns it. Most of my clients will just choose to use their name because it's easier, but it's important you know the name of your trust because when you're moving assets into that trust, you need to make sure that the right name and the right title is on those assets so we don't run into any issues down the road. Question 2 for this week, what happens if my bank rejects my power of attorney? This unfortunately happens more often than you would think. You go to an attorney, you prepare a power of attorney, and you're using it and everything seems fine until one day your power of attorney goes to your bank and they say, wait a second, we're not going to honor this power of attorney. For some reason, banks get more finicky as the years go on. There's 2 ways you can then handle this. The first way, you can speak to your attorney, have them contact the bank, explain to them why the power of attorney is just fine and it's legal and it needs to be accepted. Number 2, they probably have their own form. So you can ask the bank if they have a form of power of attorney that they prefer you use. And I know it's not easy and it's an extra headache you don't want to have to go to, but if you're using their form, that's usually a good way to make sure they're not going to reject it. Just make sure you understand what you're signing and what powers you're giving under just their form. If you work with a financial advisor, for example, they will often have you sign a power of attorney with a very limited power so they can speak to your family members about your assets in case we have any questions on your investments. So it's not that uncommon that a bank will at least initially reject a power of attorney. Just know that you can go one of those 2 routes. Either show them why it's a valid power of attorney by talking to your attorney, or second, look for their form. And if you're able to, just use their form so you don't have any more issues with them. Number 3, can you draft your own deed for your property? So the answer, of course, is yes, but it's not something you want to try to do on your own. So you can look at your old deed for your property and think, I can probably just type this up and make it look fine. And just copying the old deed may be enough for you to get in the door with the registrar. However, there's a lot of other steps that can be involved that you can miss. You need to make sure you have the right filing fee. Most importantly, you need to make sure you have the right language on the deed. So in Minnesota, for example, we have to say what the marital state is of each of the grantors. So are they single? Are they married? Are they widowed? Is it coming from a trust? We need to make sure we have the correct language. That language may not have been on your first deed. So your first deed came from somebody else granting to you, and that language may not be the same as what you'll be using going forward when it comes to the granting. So you want to make sure you have the right language. Deeds aren't particularly expensive to prepare, so that's why you should work with an attorney and make sure you're getting the right form. And so if there's any problems with the deed, they can also work with the property clerk to make sure we get those fixed. Number 4, what are 3 issues we need to worry about with our business? What I call the 3 Ds of your business. Those are going to be death, disability, and divorce. So when you're creating a business and putting together your business documents, we want to make sure those 3 situations are reflected in your documents. First of all, what happens when an owner dies? Second of all, what happens if an owner becomes disabled and is unable to participate in the business, especially if you have a single member LLC or a single member company and that's the only person running the business? What are we going to do if that person becomes disabled? And third, what about a divorce? A business divorce, meaning you have partners and you've all decided to go your own separate way. It's called a dissolution. Under law, it's commonly known as a business divorce, and we need to know, do your documents have a process, a way that we can move forward if there's going to be a divorce of the business partners in this case? Number 5, last question for this week. Can you own more than one LLC at a time? Now, this was an interesting question this week from a consultation because a client already had one LLC and for some reason it got in their head, and I'm not sure if they read a blog or heard it somewhere, that you were only allowed to own one LLC at a time. Now, of course, you need to check your local state laws, but generally there's no prohibition on you owning more than one LLC. So a common situation I run into in my practice, somebody owns multiple properties that they're renting out for income. They put each property into an LLC individually, so now they have 4 or 5 or 6 LLCs, depending how many properties they have. There's no rule, there's no law against them owning those multiple LLCs. So I'm not sure exactly where the client got that question, but in case you had that question, yes, you can own more than one LLC. So those are our 5 questions for this week. The weather's getting a little bit colder out here, and we might even get some snow, but I hope you have a wonderful weekend, and we'll see you next week for the Friday 5.